You hire a talented creator to design a logo or write a code base. They deliver the work, you pay the invoice in full, and the deal is sealed with a handshake. You own it now, right? In Belgium, under the Code of Economic Law, that assumption is false. Paying the bill does not automatically buy you the copyright. Oral agreements, implied licenses, or vague line items on an invoice hold zero weight for transferring intellectual property. Belgian law assumes the creator is the weaker party in any transaction. By default, the system protects their ownership unless a specific written document overrides it. Without a highly specific, legally compliant document, the transfer legally never happened. Article 11.167 of the Code establishes the ultimate governing rule: strict interpretation in favor of the author. Broad, generalized phrases like "all rights transferred" slide right off the page and revert directly back to the creator. In practice, this means anything not expressly and specifically written down as transferred remains the exclusive property of the author. If a contract is silent on a specific use case, that silence represents a right the creator still holds. To overcome this protective default, a copyright contract requires the precision of a surgical instrument. Looking at this documentation from the Code of Economic Law, we see the stakes. A contract must contain specific, mandatory clauses, or it faces relative nullity, meaning the author has the power to void the entire deal. These clauses act as the interlocking gears of the contract. The first gear is modes of exploitation. The document must name exactly what the buyer can do with the work, whether printing it on a billboard, hosting it on a website, or broadcasting it on TV. The second required gear is duration. The contract must define exactly how long those specific rights are transferred. Third is territory. The geographic limits of the usage must be explicitly set, whether the license is restricted to Belgium or covers the entire world. Finally, remuneration. Specific compensation must be stated for each mode of exploitation. Even if the negotiated amount for a certain right is €0, that zero must be documented. Missing even one of these elements breaks the machine. The legal transfer fails, and the rights snap back to the creator. This transfer contract requires a precursor document as its anchor, the avis de qualification, or qualification notice. This notice identifies the specific original work being transferred. In Belgian law, you cannot legally transfer vague creations or future ideas in bulk. You must point to a specific piece of protected work. The qualification notice proves the existence of the right, while the contract organizes its transfer. Together, they create an unbreakable chain of proof. This level of meticulous drafting provides the bedrock for your legal and tax security. When facing a judge during a corporate dispute or a tax inspector during an audit, this document is the only accepted proof that an intellectual property transaction actually occurred. It is far safer to have a short, precise contract that covers 3 specific rights than a long, vague document that fails under strict interpretation. The written word serves a dual purpose. It acts as a sword, securing the buyer's investment, and a shield, protecting the creator's livelihood. This video provides educational legal information and does not constitute formal legal advice. Always consult a qualified legal professional for your specific situation. Navigating copyright requires precision, not assumptions. Get it in writing.